cloud.
There you go.
Okay, great. And I'm going to let all the waiting room people in, which includes Kristi. And as I was saying, I am, there we go. I'm Christie Marra. I'm the Director of Housing Advocacy at the Virginia Poverty Law Center. And I am so pleased to see so many people here joining us today. We are doing this in partnership with Southwest Virginia Legal Aid Society, and Seth Allen is their representative. Seth, if you can wave your hand or something. And then Kristi, the other Kristi, is here from Legal Aid Society of Roanoke Valley. So Kristi just smiled, but she's going to wave too. And Kristi, I need to figure out how to make you a host. Not sure, because you need to share your screen, but I will look for you. So just to tell, I think most of you probably know something about the Virginia Poverty Law Center, but we are, a statewide organization, and we do trainings on various civil legal issues. We do advocacy on various civil legal issues, and we do some major impact litigation as well. And we are working with our partner, Southwest Virginia Legal Aid Society, which, as many of you know, is the legal aid that provides free civil legal assistance to low-income folks in now everywhere from Christiansburg through Lee County. And Seth, tell me if that's not a good description, but when I started at Legal Aid a couple of years ago, the legal aid down there, Southwest Virginia Legal Aid, did not include those 7 coal counties, and they were in the service area of the legal aid that I worked at back in the day. So I have a very fond memories and feel actually still love to go down to that neck of the woods, so to speak. And then the Legal Aid Society of Roanoke Valley is, of course, our partner in Roanoke and surrounding counties. And Kristi is actually going to be sharing her screen. She started to do that. And we are going to go ahead and get started. I would encourage all of you to feel free to put your questions in the chat box at any time. And we can, work on providing you with answers either as we go through, if there seems to be a break in an appropriate moment. And if not, we will certainly spend the end of the hour that we have together today answering those questions. So I encourage you to put your questions in the chat box. All right, and we're gonna go ahead and move on to the next slide. We're gonna hand it over to Seth and Kristi now, and I am gonna put myself on mute, which I keep saying every time I do this, that boy, if people had a mute button on me that just let me, that they just could mute me anytime, I would be in big trouble. Okay, off we go.
Yeah, it's like Kristi said, I'm Kristi Murray with Legal Aid Society of Roanoke Valley. This first slide here is, we're just going to go over some things that are always true under Virginia law. These haven't arisen from the coronavirus pandemic. These are always true under Virginia law. First and foremost, your landlord cannot constructively evict you. And what that means is, instead of just kicking you out, they make the property inhabitable, and they can do so by cutting off your utilities or locking you out, or take away your free use and enjoyment of the home. If a landlord does that, a tenant does have the right to file a petition for relief from unlawful exclusion, which we'll talk about in more detail as we go through the slideshow. Also, and I know a lot of my clients, when they call for an intake, they've received a notice of eviction giving them a certain amount of days to move out. And so they call and they think that, they have to be out in 30 days or 14 days, like the notice states. And they are fearful that if they're not out by that date, either the landlord's going to show up and physically remove them, or that law enforcement will be able to come and remove them on that date. That is not true. And I know that brings a lot of comfort to my clients. You do not have to move out by the end of that notice period. You don't have to move out by the first time that you go to court. Your landlord has to wait until he goes to court, is successful in an unlawful detainer, and the court awards him or her possession of the home. Even after that, there's a 10-day appeal period during which you do not have to move. Now, if you're not out by that 10th day, the landlord can seek a writ of possession. The sheriff does have to give you 72 hours notice before they can appear to physically remove you from the property. But that is the only point at which the landlord can retake possession of the property and remove you and other occupants as well as your belongings. But that does not happen until the notice period expires, an unlawful detainer is filed and served on you. You have waited to your first court appearance. And typically cases aren't heard on the first one, so you typically go back, which buys you a little bit more additional time. But it is not until the court orders that the landlord has possession that you actually have to physically remove yourself from the house. Otherwise, they will do it for you. So it's not the rush that a lot of my clients tend to think that it is. You do have a little bit more time than that notice period and even the court date. And I'll pass it on to Seth. Well, actually, I'm going to stick with it. So those were the things that are always law in Virginia. They weren't affected by the pandemic. But now we're going to start talking about some of the temporary eviction protections and resources that protect tenants from eviction currently. First and foremost, there was the eviction moratorium that arose from an order from the Centers for Disease Control. That was issued in order to protect some residential tenants who had fallen behind on rent from being evicted. The reason behind the CDC doing this was to prevent the spread of the coronavirus, because typically if people have to move out, if they're not in a financial position to arrange new housing, they will then have to move in with someone else, and then you have more occupants in crammed quarters. And so the CDC did this eviction moratorium to prevent that from happening. And it has been in place for a while as the pandemic has moved on. And currently it's set to expire at the end of this month, but it is certainly something a tenant can avail themselves of currently. But it's not automatic, and you do have to take steps in order to avoid the eviction using this moratorium. And it will halt some evictions to prevent the spread of COVID-19. Seth?
Thanks, Kristi. Yeah, so I'm Seth Allen. Like Kristi had said earlier, I'm here with on behalf of Southwest Virginia Legal Aid, and so we're going to pick up where she had left off with. So who would the moratorium help? So to figure out if the moratorium would be right for you as a tenant, you have to look at a few different things. The first thing is that the tenant needs to be able to show that they were unable to pay rent either because they've lost some income in relation to COVID-19 or they've had an increase of medical expenses. I know I haven't personally seen that scrutinized too much, but that's sort of the threshold test that you need to ask yourself or your client. And then the second one is sort of what Kristi had touched on to, that if they didn't get the eviction stopped, that they would end up homeless. And that doesn't mean like absolutely homeless, like, they have to go sleep on the street corner. It could be just that you'd have to go, stay with a friend or do something like that where you wouldn't have your own residence. So that would be the risk to you, or a shelter or something if you were evicted. There is an income threshold, and so it probably wouldn't apply to most folks where they wouldn't be eligible for it financially. It's at $99,000 per person. So with a couple, that would bump up to $198,000. So as long as you're below that, you could ask for it. And then sort of the big one here, the number 4 there, that is just saying that the only issue that the landlord is bringing up to evict you has to be unpaid rent. So if it's anything else, then this CDC moratorium wouldn't cover you entirely. And so that's the one thing that you do need to be aware of. If they're trying to lay any other grounds out there to put you out, then that may not cover you fully, but it's certainly a place to start, is asserting this right. And then the last thing is you have to do your best to get government assistance. So typically that would just be applying for rent relief, you know, going through the steps of, you know, getting some sort of assistance that would be available to you. To me, the most important thing would be obviously the rent relief. So, so that's what you have to meet in order to look at this, a moratorium applying to you. Oh, Kristi, you're muted.
Thanks, Ed. So if it does apply to you, what do you need to do? First and foremost, you need to continue paying as much rent as you possibly can, as close to the total amount as possible. Second, like Seth just mentioned, you have to apply for government rental assistance. There are several programs, both statewide, and there are some local programs here, which we'll discuss later. And once you apply for that government rental assistance, you need to document your efforts. If you cannot prove that you have applied for those funds, then it may disqualify you from using protections of the moratorium. And like I said, we'll discuss in detail some of the resources that you can reach out to for this rental assistance. We've had a lot of success with that in my office. So once you've applied for the government rental assistance, you're continuing to pay as much rent as possible. Then you need to sign the CDC declaration. And once you sign it and fill it out, you have to give that to your landlord. You can give it to your landlord at any point during the eviction process, but the sooner the better. So as soon as you get that notice, fill out the declaration, make sure you're paying as much rent as you can, you've applied for the government assistance, and then sign this declaration and give it to your landlord. You should send a copy via certified mail to the same place you send your rent payments. And if possible, also hand a copy of it to your landlord so that you have made 2 efforts to make sure that it has been received. Also, super important, keep a copy of it for your records. Preferably, if you can make a copy on a copy machine, that would be best, but I have lots of tenants that don't have access to that, so they'll take a picture of it on their phones. If that's what you can do, do that, but make sure you retain a copy of what you're giving to your landlord. Also, if there are multiple adults in the household, one declaration from one of the adults will not work. A declaration must be completed by each adult in the household and provided to the landlord, again via certified mail and preferably by hand delivery. This last section here is where you can click to go to the CDC declaration, which you can then print and complete. And once you do that, you have availed yourself of the protections of the moratorium.
And I'll just say this about the declaration. Granted, you don't have to redo it if you've done it and you've given one to somebody, but I noticed not too long ago they had changed the format of it. I guess it's probably been a month or so now. And so in my opinion, now it reads a whole lot better. You can read it and be like, yep, that's me, and sign it. So if you happen to, you know, work with folks or, you know, suggest that to them, you might want to look at that form if you've got one of the original copies that it came out. And so, yeah, typically once you're doing that, you're also going to be looking towards the rent relief program. And so that's been really helpful for folks, I know, with our service area. And so what it is that if you apply, you can qualify for free emergency rental assistance, and it essentially pays your rent. This money isn't a loan, so it's nothing that you have to pay back. There's not, the money doesn't come to you and then you have to pay it to the landlord. Assuming you get through the application process, payment goes directly to your landlord. So ideally, once it's all said and done, there won't be any dispute that everything has been paid. And so before you apply for it, you know, first, are you eligible? So for the eligibility, you'll need a lease or just something to show that you've got that landlord-tenant relationship. You know, so if they've given you a notice of eviction, you know, that may be enough. The slides here reference things like a rent statement, text message agreement, just anything in writing. And I think for some folks who haven't had an agreement in writing, they've been encouraged to get something done when they've talked to the folks at Rent Relief, be it some sort of addendum or whatever. But I think that's something that they're really trying to get into writing, so that way they can get it paid and then have a place to stay, you know, for a few months moving forward if they've qualified and are eligible to get that extra rent assistance. And then the second thing, of course, is you have to show that you've experienced that loss of income or the increased medical expenses. And then that's pretty broad. You know, the examples here include laid off, you know, reduced hours, your employer's place of business is closed. You know, you've lost some income, either child support, spousal support, you know, whatever form of income you used to get isn't coming in like it used to.
And
You know, a big issue.
I want to jump in here, Seth, because
Sure.
I have had multiple conversations with the folks who run this program at DHCD, and they have really emphasized that almost really just about anything, any loss of income since the COVID-19 pandemic started will count. Do not worry too much about whether or not you can show a relationship to COVID. This pandemic has hit everything in the economy. So it is really impossible to say that any loss of income wasn't in some way related to COVID. So just always err on the side of applying if you're worried about that nexus issue.
And I've seen that with some of my clients as well, that we weren't sure if they would be approved because of the reason of the loss of income, but we've got them through and successfully gotten their landlord paid.
Yeah, and I'll just echo the same sentiment on that. I think if you were to have a conversation with one of the folks through the application process, almost everyone could certainly have some sort of connection there. But yeah, so those are just some examples. And the next one too, I think there's a question about this posted, is that your rent amount needs to be at or below 150% the fair market rent. And to that question, it asks if it's federal or state. I think the Virginia housing doesn't, I think I found a post where they had the,
right.
yeah, and I'll
Virginia,
pop that link in there just so they'll have it.
Yeah, Virginia housing has to set fair market rates for other purposes, specifically to deal with the Section 8 voucher program. And those are the fair market rates that are being used for this rental relief program as well. And Seth has given you the rates. They vary, they're set by the federal government, but they're based on the local area. Unfortunately, fair market rents are based on a fairly broad area. I think as broad as the, for say a metropolitan area, the metropolitan statistical area, which includes not only the city itself, but all the surrounding counties. And there, don't be surprised if that fair market rent value is not really reflective of what you can rent something for in your area. That's a fairly common thing. But I will say, I haven't heard of anybody being denied rental assistance through this program because their rent was too high. If that happens, please do let me know. I'm gonna, if you have any problems at all with the rent relief program, feel free to let me know. And I have a direct line to the people who run the program at DHCD. So I'll put my email in the chat for everybody.
All right, thanks, Kristi. And then the last thing, it's another, one of these thresholds set is the your income needs to fall within the guidelines, and that's at 80% of the median income for the area based on the family size. And I don't have that chart handily available to put in the chat box, but
well, suffice it to say 80% of area median income is higher than the income of most of the people who have been accessing the rental relief program. 70 to 80% of the people who have gotten assistance through this program so far are at 30% area median income. So again, that has not been a problem in terms of creating a barrier for eligibility.
Yeah, I think just going through the process is the biggest thing, is to actually reach out or get the other landlord to help. So but we'll carry on with that one on the next slide, I think.
So how can you apply for the rent relief funds? You apply with the Department of Housing and Community Development, as Christy said, and you can apply online there at the hyperlink that shows on your screen there. Christy's also put in a contact number if you live in Chesterfield or Fairfax County. You can apply by phone, and you can check the status of the application by visiting that link there. Also, I just want to say for those in the Roanoke service area, we are very blessed to have a dedicated full-time paralegal assisting with the rent relief applications. And we've had a lot of success. As she and I talked this morning, I think already we have gotten over $160,000 in rent paid for our clients. Her name is Austin. She helps streamline the process. She gathers the documents both from the tenant and the landlord, and submits those. She monitors the application. So if you're in our service area, give us a call. You need to apply for our services. And then if you're in a position where this would work for you, we will hand you over to Austin, and she will walk you step by step through the process. She's been a great asset to our organization, and she's helped a lot of our tenants. Because the application process can be somewhat confusing, but luckily you can almost always reach someone by phone if you're having any problems. And if you're not sure about your eligibility, there's also a link there where you can visit and check if you are eligible.
And Seth, is your organization hiring somebody to work directly with tenants to help with these applications? I know Poverty Law Center is, and most of I think all the legal aids are. So can you just let folks know about that?
I'm not sure. I think so. I think I've heard some conversation of that, but I don't know if it was just at the state, you know, they were talking about legal aids in general, us specifically, but I want to say yes, but I could be wrong on that.
Okay,
So
sorry,
don't hold me
sorry to
it,
put you on
but,
the spot about that.
Yeah, no, that's okay. But yeah, they can certainly always apply for services, and you know, someone's going to help with that process as long as you're eligible and you need some assistance. So
now, your landlord can be the one to apply, and honestly, that it streamlines the process. It gets the landlord their money faster, because if they apply on behalf of the tenant, the funds that they receive can be directly deposited into their bank account. So, I mean, it's a much quicker turnaround, especially if you're pending unlawful detainer where the landlord's already taken you to court and you're working against maybe the next court date, which happens a lot. The landlord should be the ones applying. We have found a lot of difficulty with that. And we've found that, especially where we have Austin here in my office, it's sometimes quicker to us. We do it for them. But the landlords can get their money a lot faster if they'll be the ones to complete the application.
So I have to provide a caveat to that based
Okay.
on the current situation. There has been, I think because of technology issues, a bit of a backup at Virginia Housing. And Virginia Housing is where the landlords apply for rental assistance. DHCD is where the tenants apply.
Okay.
Because of this, because they're trying to clear up this backup, they have asked landlords not to submit their application until they get all the documentation from the tenant. So that
Okay.
is slowing down the landlord process as well.
Okay.
Finally, Christy mentioned that landlords are supposed to apply on behalf of tenants. That is true. That is in language that was in the state budget, but unfortunately, that expires at the end of this month. Since the state of emergency is expiring by just naturally on June 30th, and the governor has decided he does not need to extend it, there are lots of other smaller things that have been tied to the state of emergency. Unfortunately, the requirement that a landlord apply for rental assistance on behalf of their tenants is expiring. Now, here at the Poverty Law Center, we are going to work real hard to try to get that requirement put back into the budget. But even if we are successful, there will be a gap. So beginning July 1, probably through the end of the summer, landlords are not going to be required to apply. They can apply, they should apply, but it really is going to fall on tenants to apply. And there will be these new resources at most of the legal aids, if not all the legal aids across the state, including VPLC. And, you know, Kristi did a great job explaining Austin's role. These will be folks modeled on what Austin has been doing for the past year. So we really expect that to be super helpful.
Yeah, she's been great. I know she's got her hands full now with lots of cases because we're all sending them to her. But she does a great job, and it makes everyone's life easier, the tenants, the landlords, everyone, which also helps the attorneys because then it makes it easier for us to deal with court appearances and what's going to happen. Fortunately, up until the end of this month, we've kind of had the leverage that the landlord was obligated to participate. We may lose that, as Kristi just mentioned, as of July 1st. But I will say, with my personal experience, I had a case set for this afternoon where we had gone once. We got like a 60-day continuance. We got her through the rent relief program. Landlord was paid $8,325, but they had only paid through the end of May, and our court date was today, June 3rd. And even though that landlord and their attorney weren't super excited about participating in it the first time, now that they received that check, then they had no problem giving us another 60 days to try to put her back through, because we have had success with multiple applications. If the rent is not fully paid up to, because you can apply for 3 months in advance also, and we've had a lot of success getting that. But we have also submitted second applications on behalf of tenants to try to get, if they didn't get those 3 additional months in the first round, we're applying for a second round. And once a landlord gets a check in their pocket, they're much more likely to participate in the program, which is beneficial to both the landlord and the tenant. It gets the landlord paid, and it gets the tenant to be able to remain in that home and keep their family safe. I will mention one thing that I was discussing with Austin this morning. Up until this point recently, we had to submit a lot of income verification with each application. It seems they're changing that somewhat now. They have a new asset certification where a tenant will fill out the form showing if any of their assets or all of their assets collectively are more than $5,000. If it's less than $5,000, they don't even have to provide documentation of those assets. But if they're over $5,000, then the rent relief program will ask for documentation regarding the assets that exceed that $5,000 limit. But we think that will actually probably make this process much simpler. Kristi, if you have a comment about that.
I do think they still have to provide income information, though.
And that's exactly what we thought. We've noticed, though, on the screens, if you go into the application, there is something that says that income is no longer required. I had Austin call about that this morning, and they said if the household was 3 or less, then they wouldn't need it. But if the household's over 3, then you do have to provide that income documentation.
But otherwise, you still have to state your income, but you don't have to provide the supplemental documentation.
Correct.
Okay. And are they still accepting a self-authentication to verify income for a household over 3?
I think they are, yes.
Okay. Okay. Very good.
And as far as that household of 3, that is 3 people, not just 3 adults. So if you have a single parent with 3 kids, that's a household of 4. So you would need to provide the documentation for that.
Okay. And some of the other tenant protections that are in place. This one specifically has to do with some changes to some of the notice requirements, I believe, and then when a landlord can evict for non-payment of rent. And so this is one of the protections that is tied to the state of emergency. So after the 30th, it looks by all intentions right now that that's not going to be renewed. So this won't apply after, July 1. But until then.
Until then they apply. Sorry, I didn't mean to cut you off. We are going to be, Poverty Law Center will be trying to get these requirements back into the law. But as I said, there will definitely be a gap during the summer.
So it'll be a little bit in flux there for a while. But yeah, so between now and the 30th, though, in order for the landlord to evict, they're supposed to show that they've done, these several things that they ordinarily wouldn't have had to have done. And so the first is always been required. It's, you know, you have to get a written notice that says how much you owe. The change to that is instead of 5 days, tenants are given 14 days to pay that rent. And in addition to telling them, you know, to pay this within X amount of days, they're supposed to provide information about the rent relief program and how to reach the 211 Virginia to look up for other assistance resources, that sort of thing that you might be able to get. I haven't seen that the whole time that's been in place in my personal experience, but it seems like if they've essentially complied with it, you know, sometimes the judges have been letting that slide is what I've seen, but that would certainly be what you would want to see if the landlord to do if they were trying to put you out of there for the non-payment of rent. And then again, it goes on to say that, you know, the landlord, for now at least, should be sending that application for the tenants, you know, should be applying for the relief within 14 days of sending the notice. And there's an exception to, well, let's see here. The things that can happen, I guess, to sort of stop them from doing the application process would be, one, if for whatever reason you were able to pay your rent in full, which, you know, would always resolve an eviction notice. And the second one is if you enter a payment plan, which I don't think we've talked specifically about that, but that's been a change that's out there where, you know, now certain landlords have to offer payment plans. So if you were to, you know, enter into one of those with your landlord, I guess that would stop the requirement for them to fill out that application for rent relief. Or, you know, the simplest solution, I guess, would be if you already applied, you know, because they don't want two applications out there. That's going to just result in a backlog. And, you know, it's probably some of the reasons that some of these things are behind now anyhow. And then the other thing that would let them, so let's say you didn't do any of those things. And so the landlord is now giving you the notice. It's been the 14 days, you know, you haven't done any of those things to resolve it. How can the landlord evict you at that point? It would typically be because of the rent relief would need to have been denied if you didn't pay it. And they can deny that for, you know, if you don't cooperate or provide the right documentation, which hopefully, you know, assistant, you know, like the stuff that Kristi said Austin was doing for their office can help with that process to keep it from happening. The other thing that I haven't seen much of, but it says that once they apply, the relief or the rent relief application needs to be approved within 45 days. I have had one where it was awfully close to the 45 days, but I think that was probably an outlier and not normal, you know, for it to take that long. But in theory, if it had been that long since they'd given notice and applied, then that could, you know, give the landlord a reason to be able to go and ask the court for an eviction notice to be, or eviction order to be entered. And of course, if you're ineligible for whatever reason, that would, you know, allow the landlord to proceed. Or if the rent relief program has ran out of money, which I don't think that's expected anytime soon. I think they're still well funded as far as I know. And then, you know, as long with the payment plans, I personally haven't seen a lot of people enter into those with landlords. The rent relief has certainly been the solution that most people that I've talked to and dealt with has went with to prevent an eviction. But if you did get a payment plan offered by your landlord and you're paying that, then the landlord shouldn't be able to evict you. And if you get it all paid, which this applies at all times, if you pay whatever's owed, that's always going to be a reason to stop an eviction, you know, to stop that process in its tracks. So those are just two things to keep in mind. And we can move on to the other ones here.
So another one of the protections currently in place for tenants with a loss of income is that you can ask for your court case, your unlawful detainer, to be delayed for 60 days. Now, to do that, you do have to show up to court and ask for it. If you don't show up, that's not going to happen. You also need to bring with you proof that you lost income, whether that's a pay stub showing a loss, a furlough notification, something stating that you were non-essential and therefore cannot continue working, or signed affidavit stating that you lost your wages due to COVID-19. And then once you have that and you can present that proof of loss of income to the judge, you can ask for a 60-day continuance, which, you know, it doesn't stop anything, but it does buy you 2 additional months to try to get yourself better situated to pay the rent. Now, this is currently in place, and it will remain in place until 90 days after the end of the COVID emergency, which currently that would mean this would be set to expire on September 28th of 2021. So you have that for a few more months. 60 days can make a huge difference in a landlord-tenant situation, especially when you have these other options of the rent relief programs, and those 60 days can buy you a lot of time. And it, like, again, it doesn't make it go away, but it gives you a lot more time to catch up on the rent or apply for funds or whatever else that you need to do. I'm not sure
All
where
right.
Seth has gone.
Sorry
Okay,
about that. I somehow lost my video. It said that I turned it off because I had to step out for just a second, and now I can't turn it back on. So when we get that figured out, I guess I'll appear back on here. But for now, we'll just pick up talking about the payment plan. You know, and again, this is just an option that landlords are, in some cases, are required to offer in order for the tenant who's behind in rent to get caught up and you know, to avoid an eviction. That part of the change to what used to be, you know, the eviction process for unpaid rent is going to remain in place for longer than, you know, the ones that we've been talking about. I think right now, as it says on the slide there, it's good through at least July 1, 2022. And so just to specify on that, you know, it says that if the tenant falls behind on rent, the landlord has to offer a payment plan. And then, you know, of course, they have the 14 days to pay it in full or enter it. So that's just what used to be, you know, a 5-day pay or quit. Now it's 14 days. And in some instances, if it's a particular landlord with more units, they're supposed to offer you this payment plan. And if the tenant doesn't do anything, then the landlord is going to be able to go forward with an eviction after those 14 days, like they used to do after 5 days. So what does the payment plan need to be? It must allow the tenant to pay the total amount due in equal installments over a 6-month period. And so, you know, if you just signed a lease, you know, in April and you haven't paid rent since then you'd have, you know, up to 6 months to pay those 2 months back, in addition to paying your monthly rent in order to satisfy this agreement. If for whatever reason there's less than 6 months on your lease, if, you know, it's set to expire, you know, in August, or, you know, in 3 months, 4 months, whatever, then you would have to pay that over a shorter amount of time. So how much it would be could just depend on that. I lost my place there.
Okay, you went the
Okay.
wrong way there. Can we go all the way
Yeah,
back?
but
Or someone go all the way back?
I have no clue. I'm not controlling anything, which is
Oh, okay.
probably good because I can't even
Kristi
work
is
my camera. But
you sound like me, Seth.
yeah, but yeah. So for the payment thing, as long as you're entering that plan and you do it, then essentially they shouldn't be able to evict. And I don't think there's anything else of real substantive value on that slide, aside from how the payments are supposed to be determined. But if she gets me back there, I'll double check. But I think that's really the gist of it, is that some have to offer it, and if they don't offer it, you know, it's something they should, and then you're good to go. I think there's one more.
All right, now I'm Seth.
It's okay.
What slider, did you go over the right of redemption? I'm sorry, I was.
No, I don't think we've gotten there yet. I think
No,
we're on like.
that was the slide before was the right of redemption. So
Yeah.
yeah, that's the one we're on, right?
That should be the one.
Okay.
Yeah. And I think I still got this one actually. I just didn't know that I was done talking about the. Well, here, I will add this about the payment plan. I think this is important. The landlord's not supposed to charge late fees while you're in that plan. So it's not like, these late fees should continue to accrue and make the balance go up, as long as the tenant's making their rent payments on time, as long as with that payment plan added to it. And then if for whatever reason they miss a payment, the landlord is supposed to issue another 14-day pay or quit notice and sort of start that clock again. And so now this moves us into the new tenant laws that went into effect or will be going into effect on July 1. So there has been some changes to some things that we're probably familiar with, or you may be familiar with. The first is the right of redemption. That's been available for a while. That's essentially where you've got unpaid rent. That's the only reason that the landlord's trying to evict you, and you can manage to pay that before the court date. So normally you get the notice, they're supposed to pay it within the notice. If they don't, they take you to court, and if you could get that paid before court, that would be the problem solved. And then last year that was expanded to give you more time, and so now you can pay that amount due up until almost until the sheriff comes out to serve the writ of eviction and put you out. The language for that is this 48 hours before the scheduled eviction is when you need to have done that. And I certainly wouldn't encourage you to wait that long, but essentially, for sure you've got through the court date, and likely you've got at least 10 days afterwards before the writ can go. And so it gives you some more time to pay that, but you do have to pay more the longer you wait. So if they've already taken you to court, it can include late fees, court costs, attorney's fees, sheriff's fees. So the longer you wait to redeem, the more that can be. And the change to that now is before you could do it once every 12 months. It was I guess the gist of it. There may be some instances in which you could have claimed it more than that, but the general application was you could do it once every 12 months. And so now they are changing it to where you can do it any number of times. And I think the exception to that is if it's like a smaller landlord. So if it's somebody with less than 4 properties, it's still the once per lease term, which, was before applied as once every 12 months, but technically it could be the lease term.
Yeah, I need to add a caveat to that, because those smaller landlords who have 4 or fewer rental units can only limit the tenant to redeeming once every lease term if they have given a written notice of that limitation. So that notice should be part of the lease or provided when the lease is provided to the tenant. And as Seth says, this is not something that any tenant should or would want to use as a regular payment mechanism, because it does cost a lot more to redeem as you get later and later in the process. But it is very good to know, especially with the continuation of the rental assistance program and the fact that sometimes it takes longer than anticipated to get that money, that you can pay it up until 48 hours before the actual sheriff's eviction. One other thing I forgot to say about the rental relief program and those payments is that you don't have to be behind. I think Seth said that. And B, the payment can cover past rent all the way back to April of 2020 and up to 3 months of future rent. And those 3 months of future rent are paid in one lump sum to the landlord. So it really gives people a peace of mind.
Yeah, that certainly is good. And like you said, this is going to be good to know moving forward. Really, the only substantive change is before you could redeem once in a certain amount of time. Now it looks like you'll be able to do it more often And I guess to figure out if you can only claim it once, you just need to look at your lease, because either your landlord has more than 4 units and you can do it more than once, or it's going to say that in your lease, with the exception that Kristi just mentioned. So, and then the only other note, the notes in here talk about, the landlord is supposed to give you the exact amount in the notice. They are supposed to do that. I don't see that they always get that right. So, just expect that may be a little bit off sometime, but it's certainly something that they should do. And then if you do redeem, and this is probably an important thing to keep in mind for you or your clients, is that the landlord is supposed to cancel the eviction. So make sure that they actually take it off of the docket. And then also they need to mark it as satisfied, so that way it doesn't look as though there's an unpaid judgment out there. And so those things are normally you can do if you make that first appearance and it's done. You can ensure that all gets recorded the way it does. But you want to just remember that and not just give them the money and then not think about it anymore, if there's a court date pending. And again, if they do something shady like that and take you on to court, even though you paid, and get a judgment and sends the sheriff out to put you out, that would go back to what Kristi talked about earlier, being the unlawful exclusion. They've put you out without the right to do so. So hopefully that wouldn't happen, but if it did, you would have something that you could do to get some sort of relief. And I think that now has a little bit more teeth to it too. So that'll cover the right of redemption.
So what do you do if your landlord does try to use self-help eviction against you, which would mean cutting off the power, changing the locks, making the home unsafe? What can you do? You can go to court and file what is called a tenant's petition for relief from unlawful exclusion. And you'll file that in the general district court in the county or city where the rental property is located. The court must schedule a hearing on that motion or on your petition in the first 5 days. And thankfully, Kristi's organization, the Virginia Poverty Law Center, they have an illegal eviction toolkit. And if you visit their website, you can find more information on how to file for an unlawful exclusion on your own. Also, if you think you would qualify for legal aid services, this is something that we can assist you in doing as well if you qualify. I have a couple of these cases pending currently. And a new provision allows not only for you to recover your actual damages, such as hotel rooms or the loss of food in the refrigerator if the power is cut off, any actual damages that you suffer due to the unlawful exclusion, you can recover that. But now there is also an additional $5,000 that you can recover from the landlord if you are illegally evicted. And that it's either $5,000 or 4 months of rent, whichever is more, not less. So that's a new change we're pretty excited about. And then, as I said, you can also recover damages for the illegal eviction, including your actual damages that you suffer. I have one client that had to be in a hotel room for over 2 weeks, and we are asking for all of that cost because it was only due to his landlord's actions of excluding him from the property that he incurred those expenses. Otherwise, he would not have. So we'll be asking for both his actual expenses. And then if we don't file the case until July 1st, we'll also be asking to recover that $5,000 or 4 months of rent, whichever is more. Also, the unlawful exclusion is an affirmative step that a tenant can take once the landlord has excluded them from the property. Previously, when a landlord filed an unlawful detainer against you, you couldn't use the state of the property or a problem as a defense, but their new law has been codified, and now you can use the state of disrepair of the property, the state of the property as a defense, but you do have to pay the rent into escrow also into the court like you would if you filed a tenant's assertion, which is a more affirmative action rather than a defense. I just wanted to throw that in there too. But this is a great mechanism by which a tenant can try to make themselves whole again when a landlord has acted above his ability to do so under the law. And then I'll pass it back to Seth.
All right. And with that $5,000, I think that's really great for tenants, because a lot of times the conversation I would have would come down to, especially if they were wanting to get out because it was bad anyways, is there really wasn't any damages or incentive for them to benefit from taking it to court. And so now they get something to compensate them for that trouble and headache and all the stuff that comes along with it. So I think that's good. Okay, the other change that started, that's going to start July 1st, is the consent to enter home during the pandemic. It's similar to what it's always been, is that, a landlord can't just walk in. They're supposed to give, at least 20, it is now at least 24 hours notice for maintenance. And then now that's going to be extended back to, or let's see, it's 72 hours for the routine maintenance. Unless the tenant requests it. So if you ask for something, you can't really be surprised if the landlord comes in or sends somebody to come into the place and fix it. Now, one exception to that is that tenants can give their landlord a written notice that they do not want non-emergency maintenance. So if you don't want folks coming in and changing like air filters or, something like that, you give them notice to let them know that you don't want folks coming in there if you're concerned for your health because of it, or if you're going to get exposed to something. And then it's going to limit what they can do. Instead of just having to give you that 72 hours notice, now they shouldn't do it any more than once every 6 months. And then when they do come out in the 6 months, they're supposed to give you at least a week's notice. You need to consent to that time to make sure it's okay for you. When they send somebody in there, they need to be wearing all the personal protective equipment that they need to, that's going to be required. So if that's, masks, or I'm not sure if that'll be around too much longer, but whatever it is, they're supposed to take those steps to keep you safe. And an exception to that is if they have to come out to verify it for like a mortgage, if there's like insurance on the property and the mortgage company needs them to look at it or something like that.
Yeah, I mean, the problem with this legislation is that it really isn't going to be all of these special provisions that Seth just went over really will never be effective, probably in our lifetime, hopefully in our lifetime, because the state of emergency, this law goes into effect the day after the state of emergency expires. So sorry about that. We didn't anticipate that timing happening that way. However, what is good about this and what is effective, and I think will make a big difference, is the change from landlords having to give at least 24 hours notice of routine maintenance to 72 hours notice. That is not tied to the state of emergency. That part is a permanent change. And going from getting a day's notice to 3 days notice, I think can make a big difference.
Absolutely.
Also, starting on July 1st this year, you cannot waive any rights that you hold under the Service Member Civil Relief Act, which applies to members of our military. Before this date, a landlord could include a lease provision which required a tenant to waive their rights under the Service Member Civil Relief Act. That is no longer permissible. You cannot be forced to waive your rights under that act. Also, if this act applies to you, if you're a member of the military, it also permits you to get a 90-day continuance of an eviction that's filed against you. And that, of course, that doesn't apply to non-service members, but those that are in the service, that's an extra 30 days beyond just the 60-day that you can ask for if you've had a loss of income due to COVID. So you cannot waive those rights anymore, and it does permit you to ask for a 90-day continuance of any court hearing, so that you can arrange to maybe get your rent caught up or take care of whatever problem that there is. And I think that pretty much wraps up the things that we wanted to talk about as far as the laws that are changing and what's going into effect statewide. But I did want to share with you, and Seth will do this next, some of the local resources that are available here in our Roanoke service area for legal aid of the Roanoke Valley. These are in addition to any assistance you may receive on the statewide level. We have the Roanoke Area Ministries, which we call RAM here in Roanoke. They are able to assist with rent, mortgage, or a first month's rent and security deposit, and utilities. Now, that first month rent security deposit, that could be very helpful in the event that for one reason or another you can't prevent the eviction and you are in desperate need to get out and find a new residence. This program can try to get you on your feet there, get those sums that are due before move-in paid for you. And the number there is provided on the screen. Another organization, which is just a building next door to us, is Total Action for Progress, which we call TAP. They have a Roanoke City rent relief program. You do have to have a COVID-related income loss. I do think they scrutinize that a little bit more than they do at the statewide level with the rent relief program. But I've had tenants that have had success through this program too here on the local level, and that number is provided as well. And whether or not it's related to an eviction, a lot of tenants, especially those that qualify for our services, sometimes are having difficulty paying utilities or paying the deposit required to open a utility account. You can call and see if you qualify for assistance at the number provided on the screen or on the website if you click that link. A lot of times that is a lifesaver for some of our clients. And those are some of the local resources available here in the Roanoke service area. We cover Salem City, Roanoke County, Roanoke City, Bedford, Franklin, and several of the other counties up. So these local resources tend to also service that area, except maybe the Roanoke City Rent Relief Program that might be more limited to residences located within the city limits. But those are additional resources that you can apply for in addition to any of those statewide. And then I'm going to pass it on to Seth so that he can discuss the local resources available in his service area of the Southwest Virginia Legal Aid.
Okay, let's see. All right, I'm not muted. Good. Yeah, so we have a pretty big service area, so I'm not going to pretend to be able to spout off every place that we have within the whole areas that we cover, and what they cover, and what they can help with in the specific counties. But I will give you a couple that I was familiar with and that was passed along to me. So for like our Christiansburg office that serves those counties, Floyd, I think they're pretty much listed right there under the community action, the majority of the counties that they serve. But there's a New River Community Action. That's a place that you can get some assistance with, certain housing expenses and I guess rent. I don't know. I've not really worked with them since that's not the office that I'm out of. But then another resource that one of our attorneys in that office recommended was the Women's Resource Center. So those are two that's, for the Christiansburg area that you may want to reach out to if you need any help and to see if they can offer any assistance to you. The ones I'm more familiar with would be on the next slide. These are folks that help with assist clients that are in, areas of like Washington County, Smith County, Bristol, Wythe County, Carroll, Galax, those sorts of areas. And that's on the next slide there, Kristi. And those folks include, and these are somewhat specific to where you live, which county you're in. So maybe calling something like, I don't know if the 211 would specifically link you up to these things or not, but you could certainly call our office and we refer people to help, get help from these places a lot. It's Hope Ministries there out of Wytheville. People Inc. has an office here in Abingdon. And then I believe they also serve some of the counties out in the coal field as well. Rooftop of Virginia, that's they assist folks down in Carroll County, Galax, Grayson. And then there's both the Abingdon and Bristol Faith in Action that's there for folks that live in their areas there within those two cities. And they're all really good resources and real good people to talk to and work with. So I would certainly recommend them if you're near any of those places and need some help, give them a call and see what they can do for you.
So I know that we are just a few minutes over time, and I want to be respectful of your time. I have tried my best to answer all of the questions in the chat box as they came up, just to be efficient. But we don't really have time today to talk about what you like best and least about your rental housing. I would love to hear that. However, we're really trying to get a picture of what rental housing is like, particularly for low-income people across the state, so that it can help just inform us in terms of what trainings need to be done, what partnerships need to be formed, and maybe where we need to go to try to, talk to folks about how we can be helpful. So if you do get a chance, I have put, and I will put it in the chat one last time. Here is my email. Please do email me and let me know your thoughts on the status of rental properties in your area. Is there enough affordable rental property? Not enough? What does affordable rental property look like in your area? And there's one last question. How can we look into just overall regulations for landlords? Basic things like having a clean unit, appliances working, not demanding a renewed lease 2 months after you start a lease, etc. Some of that is already in the law. You certainly, most places have 12-month leases and things like that. However, you're right, we don't have standards for rental units. It's really a burden that is placed on tenants to go in and look at the rental unit before they start the lease, and make note of all the things that are wrong and ask the landlord to fix it. I am a big supporter of some type of rental inspection. Kristi could talk more. We don't have time right now, but Kristi works in a location where they have a rental inspection district, to the extent that Virginia allows such things, right? And she could talk more about how helpful that is. That is a whole nother hour-long training. And you know what? If there's interest in that, again, email me if you want to talk more about what a rental inspection district is currently, how it works in Roanoke, and how we can together advocate for that to be something that can be statewide. Kristi and I are free to do that, right? I'm volunteering you, Kristi. But the Kristis would be happy to do that for you sometime, maybe even later this summer, maybe in July or August. So please email us and we will put our heads together on that one.
Yep.
And with that, I want to thank everybody, but especially Kristi and Seth. You guys were great presenters. Thank you so much for doing this. Thank you to everybody for tuning in for our lunchtime tenant training session. And please, let me know what you want from here, and we will do our best to make it happen. And for now, I'll just say bye, everybody. Enjoy the rest of your Thursday.
Thanks.
Bye-bye.
Thanks. Goodbye.